Hi, welcome to my channel and please don't forget to like, comment and subscribe. Today I bring a topic about Maritime Law Key Concepts. Maritime law or admiralty law refers to the body of law which regulates ships, the commercial nature of shipping, navigation and other nautical matters. The maritime law is particularly crucial to nations situated by a body of water where much of the commercial activity hinges on the shipping activity to and from the nation. Decree Law number 23/1982 on the insurance of the maritime law or the Old Law was the Kingdom of the Bahrain's first coherent legislation regulating maritime law. 4 decades later, the kingdom enacted a new maritime law under Decree Law number 10/2022, promulgating the maritime law or the maritime law or the law, which draws upon new elements in relation to vessel registration, vessel seizure, and also maritime commercial activities, among other matters. This article shall cover the key concepts under the maritime law and the address any amendments in these features in the comparison with the old law, more regulation in anticipated in the coming weeks and months by the way of ministerial resolution issuing the implementation regulation to the law, which has come into force on 6 October 2022 for areas that are addressed further under the implementing regulation and other ministerial resolutions. We defer discussion of the subsequent articles once these legal instruments are enacted. The key concepts under the maritime law: vessel registration. The registration of vessels is regulated pursuant to Article 5 of the Maritime Law. In essence, vessels that are owned by Bahraini or GCC national or companies will qualify for registration, although foreign-owned vessels may qualify for the registration if resident or has elected domicile in the Kingdom of Bahrain. Vessels with a gross tonnage of 150 tons or more are required to register, with the exception of vessels constructed more than 20 years ago at the time of submitting the registration application. Vessels which have not been registered are prohibited from sailing under the flag of Bahrain. Carriage of goods by sea and the bill of lading. Carriage of goods by sea is an important pillar of maritime laws in the jurisdiction across the world, as they form the basis of commercial relationship between companies. The maritime law regulates the carriage of goods by sea and the bill of lading in Articles 2017 until 2082. The bill of lading is a document which proves the carriage of goods contract and serves as the carrier's receipt or shipment under which the shipper undertakes to deliver the goods against the return of the document. This document is issued by the courier upon the shipper's request following receipt of the goods or their loading on board the vessel. It is important to distinguish the role of various parties. The shipper refers to the party actually transporting the goods to their destination, whereas the carrier refers to the party who contracts with the shipper to transport the goods. The draft maritime law or the draft law addressed the bill of lading differently than in the final implemented maritime law article. On 2018b of the draft law stipulated that the contract of carriage of goods by seas shall only be established in writing through the bill of lading. This was likely to lead to practical issues since the bill of lading is issued by the shipper upon the carrier's also request after the goods have been delivered or loaded onto the ship. It is therefore to put plausible to have the bill of lading serve as the only document which establish the contract. Accordingly, Article 2018b now stipulated that the contracts of the carriage of goods by sea shall only be established in writing. Mortgaged vessels and precautionary seizure mortgages. Also, ships are akin to other assets that are capable of being mortgaged and subject to legal seizure. When mortgaging a vessel, a ship owner agrees to provide bank or lender with an interest in the vessel as security for a loan. Pursuant to Article 47 of the law, a mortgage on a vessel may only be carried out through a notarized contract, following which it shall be deemed null and void, although the old law did not limit said contract to take the form of an official notarized document. The Civil Code paved the way for this requirement, stipulating that in the absence of any provision to the contrary, a mortgage shall only be concluded over the real property, and a mortgage shall not be deemed concluded a value or unless made under an official document. Furthermore, mortgages on vessels now extend to their machinery, equipment, and fixtures by virtue of Article 14. To maximize the potential financial utility of a vessel, the law provides that a mortgage may be registered against a vessel that is still under construction, contrary to what one may initially expect. Mortgages taken even against a vessel nonetheless remain on its wreck. So thank you for watching, and don't forget to like, comment, and subscribe.